Good news for immigrants. $112 million IC lawsuit and USCIS fee blocked. This week, two significant court decisions have reshaped the immigration landscape. Both deliver rare accountability and renewed clarity for immigrants, advocates, and local governments nationwide. A federal jury in New York awarded $112 million in damages to immigrants unlawfully detained under IC detainers. Meanwhile, a separate court order has temporarily suspended USCIS's controversial $100 asylum fee. Together, these outcomes reflect a critical moment of judicial oversight, highlighting the importance of due process in the administration of U.S. immigration law. Federal court rules against Suffolk County. The $112 million verdict arose from a class action lawsuit against Suffolk County, Long Island, concerning detentions that occurred between 2016 and 2018. After completing their sentences, or after their charges were dismissed, 674 individuals remained in custody because IC requested local authorities to hold them for pickup. These detainer requests were administrative forms, not judicial warrants. The court ruled that the county violated the Fourth Amendment by extending detentions without legal authorization. The decision emphasizes that local governments cannot substitute IC detainers for lawful warrants. Federal requests must not override established constitutional rights or local legal obligations. Law firms Winston & Strawn LLP and Latino Justice Proldef represented the plaintiffs, arguing that prolonged detentions occurred without probable cause or judicial review. The federal jury agreed and imposed financial penalties reflecting the severity of constitutional violations. The U.S. Court of Appeals for the Second Circuit later upheld the ruling. This outcome reinforces that cooperation with federal immigration authorities must remain within constitutional limits and subject to proper legal oversight. National implications for local agencies. Although the case originated in New York, its implications extend nationally. Many local jurisdictions still comply automatically with IC detainers to avoid conflict with federal agencies. The verdict establishes that local officials risk substantial civil liability if they detain individuals beyond their lawful release dates without a warrant or court order. Counties and municipalities may now reassess their detention policies, introducing stricter compliance reviews to prevent unlawful collaboration with federal immigration enforcement. Beyond financial consequences, the case underscores the broader principle that immigration enforcement remains bound by constitutional standards. For immigrant communities, it is a reminder that federal cooperation does not eliminate the right to liberty once criminal proceedings conclude. This ruling is therefore viewed as a structural correction, realigning the boundaries between local law enforcement authority and federal immigration jurisdiction. Deeper legal structures at work. The Suffolk County case is part of a broader constitutional debate surrounding local participation in federal immigration enforcement. Courts have long clarified that IC detainers are voluntary, not mandatory. Federal courts have repeatedly ruled that holding individuals solely on the basis of a detainer request, without judicial approval, constitutes an unlawful seizure under the Fourth Amendment. This means local jails risk violating both federal and state law when they comply with IC detainers absent clear judicial authority or independent probable cause. Organizations such as the American Civil Liberties Union and the National Immigration Law Center have warned local agencies about the legal exposure such cooperation can create. In many states, statutes explicitly prohibit local officials from enforcing federal civil immigration laws without a court-issued warrant or state authorization. The Suffolk County verdict, therefore, does more than award compensation. It reinforces the national legal precedent that constitutional safeguards apply equally to non-citizens. It also represents a growing judicial trend, reminding public institutions that administrative cooperation with federal agencies cannot override constitutional protections or local autonomy. For future cases, this ruling may encourage additional litigation in other jurisdictions, leading to more consistent interpretation of detention authority across the United States. USCIS $100 asylum fee temporarily suspended. In a separate case, a federal court has halted the implementation of USCIS's new $100 asylum fee. The fee had been introduced earlier in 2025. USCIS stated that the charge would support operational costs and backlog reduction. However, applicants and advocacy groups described the rollout as poorly communicated and administratively unclear. Multiple lawsuits challenged the legality of the fee, citing insufficient notice, inadequate implementation planning, and lack of clarity on payment procedures. The court found these concerns valid and ordered USCIS to suspend fee collection pending further review. The agency confirmed it will comply with the ruling. Applicants who have not yet paid the fee are not required to make payments until new guidance is issued. Those who already paid will not receive refunds. The decision temporarily relieves thousands of asylum applicants from an additional financial burden while restoring administrative consistency across pending cases. It also signals increased judicial scrutiny of immigration-related fees that may have been introduced without sufficient procedural safeguards. Legal analysts believe this pause could push USCIS to review how new rules are implemented, ensuring better public communication before future rollouts. This case underscores the tension between financial self-sufficiency at USCIS and the obligation to maintain procedural fairness for applicants already navigating complex processes. The role of judicial accountability. Both decisions, one concerning unlawful detention, the other addressing administrative overreach, highlight the judiciary's continuing role in maintaining legal boundaries within U.S. immigration policy. Immigration law often operates at the intersection of executive discretion and procedural complexity. These rulings demonstrate that courts remain a vital check on both. The Suffolk County verdict reaffirmed constitutional protections against arbitrary detention. The USCIS decision reinforced the requirement of transparency and procedural fairness in agency policymaking. Together, they illustrate that accountability in immigration does not depend solely on new legislation. It also arises from judicial review and constitutional enforcement. For practitioners and policymakers, these developments underscore the importance of aligning immigration operations with both federal and constitutional standards. They also remind the public that when administrative policies conflict with basic legal principles, judicial oversight ensures the system remains balanced and credible. DV 2027 Diversity Visa Program Update. The U.S. Department of State has confirmed that registration for the Diversity Visa 2027 program has not yet opened. No official announcement has been made. Prospective applicants are reminded that dvprogram.state.gov is the only authorized platform for registration. Participation in the lottery remains completely free of charge. Individuals should be cautious of third-party websites offering priority access, guaranteed selection, or paid registration services. These are not recognized by the U.S. government. Once the official registration window opens, applicants will need a valid passport, a recent photo meeting official specifications, and accurate contact information. Historically, the entry window remains open for about 1 month. Timely preparation and careful adherence to instructions are critical for a valid submission. Until the official notice is published, applicants should focus on document readiness and remain alert for fraudulent offers. The Diversity Visa Program continues to serve as one of the few lawful immigration pathways open to citizens of countries with low U.S. immigration rates. If you found this update useful, don't forget to like, subscribe, and enable notifications for future immigration reports. Thank you for watching, and see you in the next video.